Hearing in the appeal, Birch against Birch.
My Lady, my Lords, this is an appeal, as you know, from a decision of the Court of Appeal dated the 31st of July 2015, upholding earlier decisions both by a district judge and by a circuit judge in relation to financial relief following divorce. It may be convenient to refer to the parties as the wife, for whom I appear together with my learned friend Ms. Campbell, and the husband, who is represented by Mr. Wilson, Mr. Infield and Ms. Shillingford. This is, in many ways, a rather sad and also sensitive matter, and I'm conscious of my responsibility in opening the appeal to be succinct and objective, which I will try to do, and I'm sure the same will apply in due course when you are addressed by my learned friend. The legal issue raised by the case can perhaps be formulated in the following way, namely, in what circumstances and according to what criteria can the court allow a husband or a wife who has given an undertaking to the court as part of a post-divorce financial settlement to be released from that undertaking, whether...
Or to substitute a different undertaking?
Yes, I was just about to say that. To be released from that undertaking, whether unconditionally or on condition that a fresh undertaking is entered into. Now, there are, as you will have seen, some differences between the parties in relation to that legal issue, and it will be necessary to make some legal submissions to the court and to deal with some of the authorities. But there are also significant issues as to how the relevant legal principles should be applied in the particular factual context.
Is the question really, can the court do it, or should the court do it?
My Lady, a short answer, I think, is that it's both. So may I begin with an outline of the factual context, please? And perhaps I ought to stress at the outset, just on sort of timing, that we acknowledge that the original financial settlement here was finalised as long ago as the 28th of July 2010. And the wife's application initiating the current dispute was made about 15 months later on the 18th of November 2011, which is admittedly quite some time ago. And the reason why we find ourselves before this court in May 2017 is because the husband, as of course he was perfectly entitled to do, decided to challenge the wife's application by taking a preliminary point, on which he has succeeded so far at 3 different levels, prior to the grant of permission by this court on the 25th of July 2016. And whilst the husband, perhaps understandably, emphasises the period of time during which the present dispute has continued, a matter which also concerned, as you've seen, the Court of Appeal, it is, we suggest, perhaps fair to point out that the reason why this lapse of time has occurred without any adjudication on the merits so far is precisely because the husband took that preliminary point. Of course, if the court upholds his side of the case, he will have proved to have been justified in doing so, but he surely can't rely upon the lapse of time precipitated by his own application as in itself an argument against the wife. Such an approach, we submit, would be entirely circular. Let me then turn back to the beginning of the story in the barest outline and remind the court that the wife here was born on the 12th of May 1969. The husband was born on the 1st of July 1974. In other words, it's not without significance, we suggest, that in comparing their respective positions, the husband is more than 5 years younger than the wife. The wife is now 48 and the husband is now 42.
We have, of course, read the statement of facts
I'm
and
grateful,
issues and the
my
chronology
lady.
attached
I will do no more than sketch the basic details and, in particular, what's important for present purposes. The parties, having been married on the 28th of August 1999, had, as you know, 2 children. Lauren, born on the 16th of February 2000, is now 17. She goes to Wickham High School for Girls, where she's doing A-levels in English literature, psychology and sociology, with another year to go before her A-level course comes to an end. Tom was born on the 15th of August 2001 and is therefore now 15, and he is at this very moment undertaking some 11 GCSE exams at the Royal Grammar School for Boys, prior to 2 further years leading up to his A-levels. It's therefore self-evidently a crucial point in time from the perspective of the children's education upon which their life chances will so crucially depend. The former matrimonial home in which the wife and children still reside and which is relatively near to each of the 2 schools is called Formosa. The parties separated in July 2008 when the husband left. The petition was filed on the 27th of March 2009 and the decree absolute granted on the 14th of October 2010. The financial relief proceedings were compromised under a consent order dated, as I've said, the 28th of July 2010. You will find that in the appendix to the core volume, and perhaps we might turn to that straight away. It is in the appendix to the core volume at page 23, MS number 142. And if one turns over to the substantive parts of the order, one can see that it contained a number of key features. I'm sure my lady and your lordships will have read this at least once, so I won't, unless you'd like me to, I won't read it out. But let me summarise the key features in the following way. Firstly, there was an order that Formosa be transferred to the wife absolutely. Secondly, that the wife would take over the mortgage and try to secure the husband's release from the mortgage by the 30th of September 2012, and that the property would be sold in default of compliance with this undertaking. Thirdly, there was an agreement as to who would take responsibility for various debts. Fourthly, as to schooling, that the husband would pay the school fees, subject, however, to the fact that there were already substantial bursaries in favour of each of the children, until they left those schools at the end of year 6, and that he would continue to meet 1/2 of the cost of the children's school trips and extras at secondary school, to be agreed in advance in writing. And fifthly, that all other claims, including the wife's claim for continuing periodical payments, would be dismissed. Now, enlarging on that summary, if I may, the order was clearly based on the assumption, firstly, that the children would remain in the care of the wife, and that she and the children would continue to live for the time being at Formosa. This situation was to continue, at any rate, until September 2012, thereby enabling the children to stay in the property up to, and indeed slightly beyond, the point at which Tom completed his primary education just before his 11th birthday. It was further the basis of the order that from July 2010 onwards, the wife would discharge the mortgage interest payments, that she would henceforth indemnify the husband in respect of his liability for those payments, and that she would use her best endeavours to obtain the consent of the mortgagees to the release of the husband from the entirety of his liability under the mortgage. It was furthermore part of the basis of this consensus, as the wife sees it, that in order to secure the release of the husband from his liability under the mortgage, the wife would rely upon financial assistance from her family and or from future earnings. That undertaking that she gave to secure his release had to be based on that kind of financial platform. The details of this are set out in her statement. I won't take you there, at least at the moment, but the details are set out in her statement at paragraphs 9 and at 13 to 15, which are at MS pages 207 to 209. But in short and in summary, the wife's brother and sister had assured her that they were prepared to act as guarantors under the current or any other mortgage should the need arise. And the wife also expected herself to get back into well-paid employment. As part of the financial settlement, the wife gave an undertaking at paragraph 4.4, the bottom of MS page 144, to ensure that if the husband had not been released from the mortgage by the 30th of September 2012, she would place the property on the market so as to redeem the mortgage. This undertaking, it can be inferred, was envisaged by the parties as a sort of fallback option in case the wife was unsuccessful in otherwise obtaining the consent of the mortgagees to release the husband from liability. Now, the wife paid the mortgage instalments after the husband left the property and has continued to do so. We believe, and it is a reasonable inference, that the payments are, in fact, probably less than half of what she would be likely to pay if she went into rented accommodation. The reason for that is because the mortgage has been fixed at a rather favourable rate and is an interest-only mortgage. The statement of facts and issues shows that her mortgage payments are some £475 a month, whereas the husband's rent for himself and his partner in Stratford-on-Avon is apparently nearly £1,000 a month in a property further from London, and it may be somewhat smaller than Formosa. That's paragraphs 10 and 14 of the Statement of Facts and Issues. As regards the ownership of the property, the order contains some somewhat curious provisions. Paragraph 4.4 of the undertakings relating to the possible future sale of Formosa refers to that sale being at a price to be agreed between the parties. Nonetheless, the recitals to the order also record that the husband agreed that he had no legal or equitable interest in the property and that he would, within 28 days of the grant of decree absolute, transfer his interest in the property to the wife. So far as future financial provision is concerned, and save as regards the property, the order made no such future provision for the wife and was intended to provide the husband with a clean break. The order did make provision for periodical payments in the form of a school fees order until the children entered secondary school, and provision for contribution for extras during secondary education. I should record that there is a dispute between the parties as to whether there are, as the wife alleges, substantial arrears under these requirements, especially with regard to the payment of extras which have not in fact been paid. It can, we hope, fairly be added that so far as the children are concerned, whilst the order guaranteed that they would be able to stay in the home only up to the latter part of 2012, the financial settlement nonetheless anticipated, on its express terms, that the wife would take over the mortgage and thereby maintain the property as a home for the children for a considerably longer period. The court is aware that what the wife sought and seeks in these current proceedings is that she may remain in the property, in effect, for at most another 2 years until Tom finishes his secondary education. By that stage, it is hoped that Lauren will already be at university. Tom will be in a position to start at university, subject to the successful outcome of his A-levels. Not only will this be crucial, we suggest, in the interests of the children, but it was, as I have said, anticipated, not as a certainty, I acknowledge that, but at least as a preferred outcome of the financial settlement. The parties' personal financial positions today may be summarised as follows. The husband, as I mentioned, is only 42 years old, and after a number of friendships appears, for the moment at least, to be in a settled relationship with a woman who was due to give birth to his child sometime this month. He has disclosed earnings of some £75,000 per annum, possibly with bonuses in addition. And we submit it is clear that had he chosen to do so, he could have, and possibly did, amass capital resources following the separation. Or at any rate, would be in a position to do so. In a nutshell, following the breakdown of this marriage, he was in a position, both in general and in particular financially, to make a fresh start as he has done.
I'm just trying to tot up the debts that he undertook to discharge at 4-1. Does it amount to about £50,000, Mr. Hockman?
No,
that's her debts, I'm sorry.
The debts, yes.
His debts.
41.
40. Yes, 5-1. How much does that amount to? 11?
The total
30,
stated there, my lord, at the bottom of
41.
Yes,
Thank you so much.
25 to her and 41 to him, I think. I'm not sure that it worked out exactly like that, but that at any rate is the way it was understood.
Thank you.
So, as I said, in a nutshell, the husband, following the breakdown of the marriage, was in a position, by virtue of his financial resources, both in general and in particular, to make a fresh start, as he has done. The wife, by contrast, is significantly older, and over the years since the breakdown of the marriage has had little or no earning capacity, though she now has employment, just recently, starting in December 2016. I think there might be an error in a figure in the agreed statement on this, but the employment starting in December 2016 with the Crown Prosecution Service at a modest salary. Leaving aside her...
Well, if there's an error, we'd better be told what it is, Mr. Hockman.
Lord, I'm sorry, yes.
Paragraph 11.
Thank you, my lord. Yes. It looks as if it has been. Yes, the mistake is in paragraph 10, my lord, in the at the end of the fifth line. I think that date should be December 2015. The correct date is given lower down. It's December 2016.
It's being corrected in hand.
Oh, has it?
Yes.
Thank you very much.
Certainly on my copy.
Well, it's mine says six. It should be 16 or 15.
16.
Should be 16.
That's what I thought.
Sorry if I've confused matters in any way.
That's the least of our worries, Mr.
Thank you. So what I was saying was that the wife, since the breakdown of the marriage, has had little or no earning capacity, though she now has employment with the Crown Prosecution Service at a modest salary. Leaving aside her interest in Formosa, she has had and has no capital resources whatsoever. She does have credit card debts, and her position, she says, has been exacerbated by the non-payment of any contribution to the school extras. She is, we submit, unlikely ever to be able to buy another house for herself when Formosa is sold, as she concedes it will have to be no later than 2019.
What is the equity in the house now? Then?
Well, my lord, our estimate of the equity, I can't say that this is an agreed figure, but our estimate of the equity is that it's about £150,000, but from that must be deducted the costs of sale, which amount.
Sorry, can you? I mean, we have the redemption figure of
Yes.
454,000.
Yeah.
Paragraph 13.
Yeah.
What are you saying? It's worth about 600,000.
Yes, that's what we understand. But from the starting point would have to be deducted the costs of sale, which will probably amount to about £20,000, 3%. Also, the statutory charge, because in the courts below the wife was legally aided. Here we represent her pro bono, but she has hitherto been legally aided. So the statutory charge and some costs that she was ordered to pay by Judge Waller. So that would bring the equity down to about £60,000, I think. And so both by reason of lack of capital and by reason of her limited earning capacity, her prospects of being able to buy another property in today's property market with the inflated values with which we're all familiar is limited indeed. Overall, therefore, our respectful submission is that the effect of this financial settlement has been to leave the wife in a significantly disadvantageous financial position. But, crucially, for the purposes of the present debate, she seeks no ex post facto variation for her own benefit. She may well, we would say, have been poorly advised at the time of the making of the order in 2010, but she makes no claim for additional resources on her own behalf and never has made any such claim. Her application throughout, and it is from her perspective a tragedy that even now there has still been no specific hearing on the merits of this application, but only a prolonged series of hearings on a preliminary point. Her application throughout has simply been for the ultimate date of sale to be postponed until Tom's secondary education comes to an end.
Well, of course, now it's only 2 years. But let's not forget, in 2011, when she launched this application, it was for 8 years, Mr. Hockman.
I appreciate that, my lord. We would have wanted, I say we, my learned friend and I were not involved at that early stage, but we would have wanted that application to be determined on the merits with evidence heard at some point, at some much earlier point. But we are where we are.
Indeed.
And the reason we are where we are, we respectfully submit, is, as I said earlier, because of the taking of this preliminary point, the misconceived, as we submit, reliance upon the authority of Omielan, which does not support the husband in the argument that he puts forward, which is a point that I will develop a little later in coming to that slightly intricate case. So it is that series of hearings proceeding it has to be said, at a somewhat leisurely pace, which has led us to be where we are. I simply made the point that it can't be a point to which your ladyship and to which your lordships would be entitled to attach weight against.
Well, you've already said that, Mr.
Yes,
Hockman.
thank you.
Mr. Hockman, you've been updating us to the present financial position, which presumably is largely a question of instructions rather than proper evidence, and no doubt that's helpful. But when we listen to that, some of us will have been thinking about the husband's open offer to which Mr. Wilson has referred.
Yes.
He didn't actually explain when that open offer was made.
Yes.
We assume it was rejected, but we don't know what the wife's stance has been, apart presumably from its rejection. When was it made? And
It was made approximately a month ago, my lord. And
what did the wife say about
my
it?
lord, your lordship is right that it wasn't accepted, and I was about to come on to deal with that.
Well, please do.
As I said, her application is simply for the ultimate date of sale to be postponed until Tom's secondary education comes to an end. And it is this, as we would submit, modest objective, not modest from the children's point of view, which the husband has resisted. What we say with regard to the offer is that for the first time in more than 5 years, in that offer, the husband manifested an element of flexibility in regard to the date of sale, which hitherto is something that he has never for one moment conceded. But he was only prepared to agree to that element of flexibility at a price. And the price was a share in the already very limited equity in the property, taking the view, it would seem, that he should secure that entitlement without any responsibility, without any continuing responsibility for continuing financial support for the wife, despite the significant disparity in their respective earning capacities. So what we would say, my lord, is that it wasn't an appropriate or fair offer when you consider the financial positions that currently obtain. It was partly in order to put the offer into context, and knowing that your lordship would want to put the offer into context, as you've kindly just indicated that you seek to do. It was precisely for that reason that I set out a comparison between the parties' financial positions, and with respect, it isn't really based on instructions. I've taken the key facts from the statement of facts and issues, so the facts about what each party is doing and where they live and so forth. That's all based on agreed facts. The only fact which isn't agreed is the equity in the house. I don't think that is an agreed figure. But
you're asking for the application to be remitted to the district judge to be heard at last on the merits.
yes,
The district judge would have a lot of matters to weigh. He would have to try to consider whether the proposed release from your client went to the primary territory of the property adjustment arrangement. And if it did go to the primary territory, your client would fail again. But if it didn't go to the primary territory, there would be many other considerations, including in particular the detriment which the husband has suffered as a result of being a nominal co-mortgagor for all these years. And it might well be, Mr. Hockman, that a district judge would find that there had been detriment and that there should be some sort of compensation if, in fact, your client was, for the last 2 years, to be released. And so it may be that we will have to give, or somebody will have to give, possibly a district judge, possibly us, closer consideration to this question of some recompense for the husband. If the equity is 150, he is suggesting 50 to himself and 100 to your client.
Yes.
Broadly, although it's 30%, not 33%. So all this at some stage may have carefully to be considered, Mr. Hockman.
Well, my lord, of course I accept that. We wanted and would still wish to have a hearing on the merits, unless your lordships feel able to decide the matter in our favour in this court. Our preference would be for there to be a hearing on the merits in precisely the way that your lordship has.
I absolutely understand why you have to deal with the open offer, Mr. Hockman, because it's there in the documents and we've all seen it. But I do want to understand where you say where you want us to go, because you've been arguing the merits for the last 10 minutes or perhaps a little longer. Do you actually want us to go to the merits or not?
My lord, as I said, our preference would be, if your lordships are persuaded that there is a serious argument to be had on the merits, that be remitted to be dealt with on oral evidence, unless your lordships feel, and at the moment I don't detect an overwhelming feeling in this direction, that the merits are clearly in our favour. Obviously, if that were the case, we wouldn't be seeking to persuade you to send it back.
Remit it unless you win hands down.
Well,
Okay.
Your lordship will understand why
I understand perfectly.
I take that position. But in principle, I would submit that the correct approach should be, if your lordships are with us on the law, the correct approach should be that the matter ought to be remitted for the kind of hearing on oral evidence which has never hitherto taken place. And, my lord, going back to, if I may, to my Lord Wilson's understandable comments about the offer, I mean, I want to make perhaps or to emphasise two points about that. One is a background point, and one is a more specific point. So the background point, as I say, is that you can't view an offer of that kind in isolation from the parties' respective positions. Even though the offer is made in the context of the wife's desire to stay in the property for another 2 years for the benefit of the children, you can't view that in isolation. You have to consider the parties' respective positions. Mm-hmm. And our respectful submission is that the effect of this settlement, looking at their positions as a whole, is unquestionably to leave the wife in a less favourable position than the husband. So that what one would be doing if one said that she has to accept a proposal of that kind is to make the disadvantage worse for her. She is already experiencing what I think could be called she's a classic example of relationship-generated disadvantage already. She's in a position where at an older age than the husband, with significantly lower earnings and with a significantly reduced ability to raise capital, she's almost certainly never going to be able to buy a property. He certainly will be at the latest in 2 years' time. So all that you'd be doing, looking at the overall context, is to make her position worse. But secondly, looking at taking my second and more specific point, as I said, from the net equity has to be deducted the costs of sale, which will be about £20,000. From the net equity has to be deducted the statutory charge, which I'm told is worth £65,000. the costs which he was ordered to pay by Judge Waller, which is about £3,000. So that...
Well, if there was, by virtue of any district judge's direction on remission, some sort of award out of the proceeds to the husband, that would take precedence over the statutory charge, wouldn't it?
Well, perhaps it would, but surely, with respect, my lord, the net result of all these deductions from her side of the equity would be to leave her not with £100,000, but with significantly less than 50.
Yes.
So not only would any order for her to pay him be, in the wider context, unfair, we suggest, because of the comparing the relative positions, but then if you then say that the distribution should be in the form that we've been discussing, he will actually get a significantly bigger share of the equity than her, because her deductions are very much greater. So, in principle, awarding him a share of the equity would be unfair, and on the figures, the net result of his proposal would be to give him about twice, we think, what she would end up with if that's the way it worked out on present values. I mean, his proposal is that these figures should, as it were, be worked out in detail in 2 years' time, but on present values, she would end up with about half of the amount that he would end up with, because her share would be subject to these deductions.
I'm very grateful to you for addressing us at length on your response to the open offer. That was in response to my question.
Indeed.
But no doubt you need to get on with the substantive presentation.
Yes, thank you very much, my lord. Let me then turn to the legal issue, if I may, and make my submissions on that. And I wanted to begin by setting out some starting points. I have 5 submissions to make of a general nature, which I hope will be of assistance to the court. First, we would submit that in the case of orders for financial relief, whether by consent or otherwise, Parliament has drawn a line between a class of order which is not susceptible to variation and other classes of order in respect of which an application for variation may be made. The statutory power of variation is in section 31 of the Matrimonial Causes Act 1973 as amended. My lords, I don't know if you'd like to take a glance at that by way of reminder. It's in volume 1 of the authorities bundle, tab 6, MS, page 374. And there at page 374 is section 31, giving a power to vary or discharge an order. Section 31 applies to a range of different things. It applies in particular by 31(2)(f), about 3/4 of the way down, to an order for sale under section 24A1. But as we know, it doesn't apply to a property adjustment order or an order for variation of settlement. But where it does apply, on page 376 at subsection 7, the court shall have regard to all the circumstances of the case, first consideration being given to the welfare while a minor of any child of the family who has not attained the age of 18. Section 24A is at tab 3 in this bundle at MS page 366. And it provides that where the court makes an order for a property adjustment order, for instance, then on the making of that order or at any time thereafter, the court may make a further order for the sale of such property as may be specified in the order, being property in which, or in the proceeds of sale of which, either or both of the parties to the marriage has a beneficial interest. And at subsection 4, where an order is made under subsection 1 above, the court may direct that the order or such provision thereof as the court may specify shall not take effect until the occurrence of an event specified by the court or the expiration of a period so specified. Then at tab 4, page 368, at subsection 1, section 25, subsection 1, it shall be the duty of the court in deciding, and this is, of course, familiar language, it shall be the duty of the court in deciding whether to exercise its powers under section 24A, among other things, and if so, in what manner, to have regard to all the circumstances of the case, again, first consideration being given to the welfare while a minor of any child of the family. So both the original power under section 24A and the power of variation under section 31 are by statute to be exercised with first consideration being given to the welfare of the minor children. I pause there just to remind your lordships that the original application to the court here was expressed to be under section 31, although it has also been treated as an application under the court's original jurisdiction. Our submission, as you know, is that this case is one, or at least is closely comparable with one, in which a statutory application for variation would be permissible. So this is, if this isn't actually a section 31 case, it is closely comparable with a section 31 case. Alternatively, putting the same point in another way, on any view, our application is consistent and not inconsistent with legislative policy.
Sorry, does it matter that it's a variation of an undertaking, not an...
Well, my lord, that's the reason why I say that it may be correct to describe it as closely comparable with a section 31 case rather than precisely within the four corners of section 31. But our submission is...
But I mean, sorry, as a relative newcomer to this field, it would be nice to be clear what provision you are relying on as justifying the variation of the undertaking as opposed to the order. You're saying the inherent jurisdiction in a manner analogous to section 31.
Yes, I think that, with respect, my lord, is an accurate way of putting it, yes.
As I understand it, Judge Waller, the circuit judge, held that the undertaking could have been framed as an order for sale under section 31.
My lord,
and I get the impression that neither counsel in the Court of Appeal disputed that. And I further get the impression, nevertheless, that Lord Justice McComb found that it couldn't have been framed under section 31. If it could have been framed under section 31, then there may be quite a strong argument for saying that this application for release from undertaking should be dispatched upon analogous principles.
My lord, precisely. Your lordship is, I think, right that it wasn't in dispute in the court below. That's the case, and as I understand it, it's not in dispute now. And indeed, your lordship may have noticed that in the written case for the respondent,
Mr. Wilson expresses some doubt about Lord Justice McComb's conclusion.
yes.
Yes, very well.
It's at paragraph 27 of the respondent's case. So we would say that that part of the consent transaction that that stipulation could certainly have been made the subject of an order for sale under Section 24A, and had it been, then my answer to my Lord Carnwath would have been that this is wholly within the province of Section 31. And of course,
Well, subject to the Amelan jurisprudence and the question of primary territory.
well, my Lord, with respect, if it's an order under Section 24A, then by statute, Section 31 applies. Omielan, with respect, doesn't enter into that equation simply because it is something which the legislature has laid down. Putting the Omielan case against me at its highest, I suppose the argument would be that because of Omielan, that which looks like a Section 24A order actually isn't one. And we'll see when we get to Omielan that Lord Justice Thorpe really addresses that. I mean, what Lord Justice Thorpe in Omielan expressly says is that where you have an order for sale, it has to be treated henceforth as an order under Section 24A. So with great respect, my Lord, I wouldn't, as it were, agree that there's some kind of escape route from this, because there isn't. But we will see that when we come to Omielan. I was going to deal with that rather later in my argument.
Are you still on your first proposition?
My Lord, my Lady, I think I am, but I'm about to go on to the second one. Secondly, even in those cases where the variation of an order is jurisdictionally feasible, grounds for such a variation will obviously have to be shown, involving, it may very well be, some change of circumstances. But if the change of circumstances is such as to persuade the court in favour of a variation, then by definition that change will, we suggest, be significant. Nothing is added to the debate, we suggest, by insisting that the change in question must be categorised as significant by some extraneous but unspecified criterion. Thirdly, in those cases where a variation is jurisdictionally possible, there is no obvious policy reason why the available grounds should be artificially constricted in advance, save that the legal parameters which applied when the original decision was made will obviously continue to apply at the point of variation. We submit that in all such cases, whether good grounds for variation have been shown is a matter for the judgment of the court, and that it's, we suggest, unhelpful to say that this entails a judicial free-for-all. Fourthly, the fact that the original order was made by consent may be a very important element in the court's judgment, but it should not itself be and is not a jurisdictional bar, and was not treated as such even by the Court of Appeal in the present case. The husband's submission that any variation in the arrangements requires his consent is inconsistent with this approach, since it would by definition create an absolute jurisdictional bar. By the same token, the fact that the suggested variation may revisit the primary territory of the order should not be and is not a jurisdictional bar, save and unless the effect is actually to vary an order within the class which by statute the court has no jurisdiction to vary, such as a property adjustment order. A variation based on a significant change of circumstances, which, at least in the case of an undertaking, the authorities generally support, must by definition sometimes revisit the primary territory of the original order. Fifthly, just as consent is likely to be a factor constraining the court's willingness to approve a variation, so there are other factors which are likely to be treated as tending to liberate rather than constrain. These factors include the following: A, if the terms of the order remain executory, and B, if and insofar as the order contains undertakings. Now let me embark, if I may, upon a brief review of about half a dozen of the cases before I come to Omi Elan. I'll limit myself to the ones which it seems really necessary to deal with. And could I start with Thwaite, which is in Authorities Volume 2 at tab 25. Back in 1981, a Court of Appeal comprising Lord Justices Ormerod and Dunn and Mr. Justice Wood had to deal with an application for a variation of a property transfer order made by consent. The husband had declined to complete the transfer and applied for a variation of the order, since the wife had, for various reasons, not fulfilled her side of the bargain. And I remind your lordships that the wife's position in this case is that the husband has failed to contribute to the school extra expenses. Lord Justice Ormerod, giving the judgment of the court, held that where the order is still...
Have you got a page reference?
I'm sorry, my lord, my lady. So this is MS page 752, the start of the case, tab 25, and the passage which I would like to go to, if I may, is on MS page 756.
Thank you very much.
And it is the paragraph at the bottom of 756, where the order is still executory, as in the present case, and one of the parties applies to the court to enforce the order, the court may refuse if, in the circumstances prevailing at the time of the application, it would be inequitable to do so. Where the consent order derives its legal effect from a contract, this is equivalent to refusing a decree of specific performance. Where the legal effect derives from the order of the court itself, the court has jurisdiction over its own orders. So it's interesting that the learned Lord Justice deals with the contractual aspect of this by pointing out that it's equivalent to refusing a decree of specific performance, which it inherently involves, we submit, the exercise of a discretion. And by way of comment on Thwaite and on what's said here, and to make our position clear in relation to this, we do seek to rely on the fact that for relevant purposes the order remains executory, essentially because when the application was made, the date of sale had not yet arisen. That's the crucial point. At the date of the application, the wife made her application well before the date arose at which she had to put the property on the market. And I won't repeat what I've already said about the lapse of time since then. So for relevant purposes, the order was executory. Then could we please go to Kensington Housing Trust and Oliver, which is in volume 1 at tab 15. MS page number 545, in which a landlord seeking possession of the premises the subject of a tenancy gave an undertaking in a consent order to offer the tenant alternative accommodation. The question before the Court of Appeal, comprising Lady Justice Butler-Sloss, Lord Justice Thorpe and Lord Justice Judge, was whether the court had jurisdiction to release the landlord from the undertaking, and if so, in what circumstances. Lady Justice Butler-Sloss, if I may take you to this at page MS 549, towards the bottom of the page, said that an undertaking accepted by the court can be discharged by the court at any stage if it is just to do so. The fact that it's recorded in a consent order does not change its nature from a promise to an order. Lord Justice Thorpe, over the page at page 550, agreed and indicated that this principle applies equally, the first paragraph in his judgment, principle applies equally in the field of family law, where, as he points out, undertakings are a useful and commonplace medium. And Lord Justice Judge also agreed at page 552, citing towards the bottom of page 552 the family case of Russell versus Russell. If we could then go, please, to Mid-Suffolk District Council and Clerk, which is in volume 2 at tab 18. A defendant here had given an undertaking. I'm sorry, my lord, 621. 621, my lady. I am not in my handkerchief from now on, if I can. 621, the defendant had given an undertaking not to cause or permit a public nuisance, and the question before the court was as to its jurisdiction to modify the undertaking by releasing the defendant from aspects of it. On the issue of principle, Lord Justice Buxton, with whom the other members of the court agreed, at page 638, Lord Justice Buxton accepted that an undertaking could be set aside or varied in appropriate circumstances, but he pointed out at the top of page 639 that the jurisdiction should be limited to a case where it is not only just to do so, but that there's a significant change of circumstances. In L,
What was the context in which that undertaking had been given?
the undertaking was not to cause a public nuisance, my lady, and the defendant was seeking to be released from that undertaking.
Yes,
So
I understand
as I
that, but what was the context in which the undertaking was given? What was the quid pro quo? You don't give undertakings unless there's something on the other side.
See if I can find the answer to that.
Well, they were under threat of being sued by the council for a further episode of public nuisance, I think.
Yes.
Councillor got home the first time, it went on, and the second time was compromised by undertakings. Is that it?
I think so, my lord.
No, sorry, there hadn't been a finding the first time. It's the first time.
I'm sorry to have put you in difficulties, Mr.
Proceedings
Hockman.
were taken to restrain him from causing a public nuisance.
Yeah.
It's an undertaking.
There would probably have been an injunction
in
had there
April-
not been an undertaking.
Following trial of the 1993 action, the defendant gave a voluntary undertaking to the court not to cause or permit a public nuisance.
That's right.
After the 31st of May 2000, so he wanted the smell to continue for a year or so.
It's an undertaking in lieu of an injunction, isn't it?
Yeah, I think that's it.
But there was also a planning element that
Yeah.
though he was going to be subject to planning control as well. I mean, it's a fairly sort of messy
Yeah.
factual situation with absolutely nothing to do with the present case, which is why it's rather difficult to sort of see how it helps. But I mean, what you're not relying on it. You're just observing that it introduces elements of the need for a significant change.
Yes.
But I mean, are you saying that's right or wrong?
Well,
I mean, that's why I asked you what the
Yes.
context was for the
yes.
giving of the undertaking.
Yes. The test for which we contend is the slightly broader test set out in the Kensington Housing Trust case, a test which essentially involves the court deciding whether it is just to allow the party giving the undertaking to be released either unconditionally or subject to a condition that a fresh undertaking is given.
But I mean, you didn't read out the extract from Russell and Russell, which was quoted by Lord Justice Judge on page MS 552 in Kensington Housing Trust, tab 15, where he says, in order to obtain a discharge, you'd have to show a real case of hardship, some essential change in his circumstances.
Yes.
Is that right?
Well, my lord, I've accepted that in all probability, in order to justify the release from the undertaking, this was one of my general propositions, I've accepted that a change of circumstances is very likely to have to be shown. I have suggested that in practice, if the change of circumstances leads the court to release the party in question from that undertaking, then almost by definition it's going to be significant, and that nothing is to be gained by suggesting that there's some extraneous test of significance over and above that which emerges from the facts of the case.
Yes, you're suggesting it shouldn't be a threshold requirement.
Yes.
You should look at the facts of the case, and if it's just to release or change, well, then do so, and it's by definition significant. That's what
exactly
you're saying.
right.
It's not a threshold requirement.
Yes, my lady, thank you.
As a matter of interest, do we know whether Russell is a money case or is it an undertaking to do with some other continuing relationship, such as the upbringing of the children or something of that sort?
I have a copy of it here.
If it's money, is it a capital sum or is it... Anyway, we'll see.
It's money, but it's not capital. An undertaking that the husband would not in future apply to have a maintenance order reduced.
Thank you.
I was going to turn next, if I may, to L at tab 16 in bundle 2, MS page 554. A decision by Mr. Justice Munby, as he then was, in which a husband sought release from a periodical payments undertaking, relying primarily on the fact that the original order was unsatisfactory owing to bad advice which he'd received, rather than by relying upon a change of circumstances. Now, there are 2 or 3 passages in this decision which it might be helpful to pick up. Firstly, at paragraph 34, on MS page 569, please, where one sees a well-known list of the circumstances in which a final ancillary relief order made by consent can be reviewed by the court. And the list given by Mr. Justice Munby for relevant purposes includes 3, 4, and 5. 3 is where there's been a new event since the making of the order invalidating the basis or assumption upon which the order was made, the Barder type case.
Yeah, but that's a very fundamental
Yes.
requirement, isn't it?
Yes.
It's not a mere change of circumstances.
Well, if necessary, I shall make a submission to the effect that that too may be more a matter of language than anything else. But let me leave Barder to one side for the moment. 4 and 5 involve undertakings and the order remaining executory. And as you gather, our submission is that this case falls within both 4 and 5.
But he's not, at least I take it, he's not just saying that that means it's all at large.
No.
He's obviously referring back to mid-Suffolk and implying that there must be.
He also talks in terms of significant change, and we'll see that at in the next passage which I was going to refer, which is at 579, please, paragraph 67. Merely because an order is still executory, the court does not have, any more than it has in relation to an undertaking, any general and unfettered power to adjust a final order, let alone a final consent order, merely, he says, because it thinks it just to do so. The essence of the jurisdiction is that it is just to do so, it would be inequitable not to do so, because of or in the light of some significant change in the circumstances, to adopt the phrase used by Lord Justice Buxton in Clark. I beg your pardon. It would be inequitable not to do so because of or in the light of some significant change in the circumstances since the order was made.
You say that's wrong.
Well, my Lord, I don't want to repeat myself, but the way I put it is that the question whether there's been a significant change in circumstances is no doubt, in many cases, a key element in the decision that it is just to release the giver of the undertaking from the undertaking, but it isn't a precondition, we would say.
Well, not only is it a precondition in your submission, it's not an autonomous requirement. Essentially, your submission is you look at the justice of the situation.
Yes.
Justice of the situation may be impelled by a significant change in circumstances, but absent a significant change in circumstances, the justice of the situation may nevertheless require a variation.
Yes.
Well, in other words, what the judge there says is wrong.
Well, inasmuch as it suggests that the freestanding...
But let's face it, we need to know whether you're saying it's right or wrong. I mean, the way my Lord puts it does seem to be a perfectly valid way of putting it, but it's not the same as with respect as Mr. Justice Mumford is putting it.
Well, there are three possibilities, aren't there? One, what is just
Yes.
in the situation that there now is, irrespective of whether there's been any change in circumstances. Secondly, there must be some change in circumstances, but if the change in circumstances is sufficient to make it just to vary, well, then it's significant by definition. Or thirdly, the threshold requirement of significance before you decide what's just. Those are the three possibilities. My understanding was that you said you were going for the second.
Yes, my lady.
Yeah, I think that's what I understood too.
So not exactly what my Lord Kerr has put to you, because he was putting not a requirement of any change at all. But also you were saying, insofar as they suggest that it must be a significant change as a threshold before you even get on to think what might be just. You're rejecting that. Have I understood you correctly, Mr.
You have, my lady. It seems to me that to limit oneself, I don't know that this is what my Lord Kerr was suggesting, but to limit oneself to the circumstances obtaining at the time at the moment of suggested variation, and to set and effectively retake the decision on new facts would be over ambitious. That would be a submission going beyond what the law requires. But, so yes, I take my stand on position number 2. In dealing with undertakings, I ought perhaps to enter this caveat that and repeat what I said earlier about Section 31. Of course, if this is a Section 31 case, or at least the equivalent of Section 31, then in such a situation, the approach of the court has to take into account, has to follow the guidance given in Section 31, taking into account all the circumstances and giving primacy to the interests of the children. There are two more. There's one more passage in L, which I need to show you, which is at MS page 593. And it's at paragraph 113. And here Mr. Justice Munby acknowledges the relevance of Section 31. Section 31 entitles the husband to apply for an order varying, discharging or suspending that part of the consent order which constitutes an order for periodical payments. I might add in brackets, and also an order for sale under Section 24A. That entitlement is not in any way affected either by the fact that the order was a consent order or by the fact that the relevant provisions are contained in undertakings rather than the curial part of the order. Nor, and on this point I agree with Mr. Howard, is it a necessary prerequisite to the exercise of the jurisdiction under Section 31 that there has been some change in circumstances since the order was made. No doubt, as Mr. Scott observes, the court will usually be reluctant to intervene, absent any change of circumstances, whereas here the order was made by consent and less than a year before the application is made. But that goes at most to the way the court may usually be expected to exercise this jurisdiction, not to the exercise of the jurisdiction itself. And then he says at the end of that paragraph, Section 31 is a statutory jurisdiction to vary, discharge or suspend a periodical payments order. The fact that in a particular case, some exercise of this jurisdiction may be indistinguishable in its practical effects from a successful appeal is neither here nor there.
So you're saying that's right?
I am.
Good. It's nice to know where you stand.
I was going to mention Barder, but I think in view of the time and in the light of your ladyship's comment about Barder, I will leave Barder and come back to it in reply if I need to do so. I will leave Barder to one side. There's only one more case that I want to refer to before I come to Omielan, which is Bezeliansky, which is in Volume 1 at tab 11.
Yes.
page 500, an application to set aside a consent order, and can I take your ladyship and your lordship straight to page 508, towards the bottom of the case, towards the bottom of the page. About 10 lines up from the bottom. With respect to cases where there is an undertaking or an order that is still executory, the approach to determining whether or not to set aside or vary the order is, as the appellant submits, based upon it being inequitable to hold to the terms of the original order in the light of a significant change of circumstances. Same again.
Is this the case where the genesis of the problem was that there'd been an order to transfer a particular property husband hadn't got?
Yes.
Well, it's fraud or mistake then, isn't it? That's inevitably.
Yes.
One or the other.
Yes.
It's certainly not a change.
Except the discovery of the fraud.
Taking stock, therefore, if I may, of where we've got to so far before I come to Omiyale, my submissions are these. The courts have employed a range of different formulae to classify and or to justify a decision to discharge the giver of an undertaking from his or her promise and to accept a fresh undertaking. Understandably, the courts seek to identify the factual circumstances making it appropriate to exercise a jurisdiction which undoubtedly exists. Sometimes those factual circumstances are described in terms of invalidating the prior basis, sometimes in terms of a significant change of circumstances, sometimes even in terms of bringing about a different outcome. But in the end, as a matter of legal principle, the Court of Appeal was correct in the Kensington housing case to say that an undertaking can be discharged at any stage if it is just to do so, and that the various individual formulations listed above should not be treated as laying down minimum criteria. And we submit that this result does harmonise with the statutory position under which, in effect, an order, as distinct from an undertaking, can in general be varied, and on the basis of a consideration of all the circumstances, including especially the interests of the children of the family, save in the case of a final order for an adjustment of property or a lump sum. Even in such a case, we point out, even in such a case, there would be jurisdiction to review an order if it remained executory, and there would also be jurisdiction to review an undertaking expressed to achieve an equivalent result, but no doubt such cases would indeed be exceptional. On any view, in the case of an application to vary an order for sale under Section 24A of the 1973 Act, the jurisdiction is unrestricted. Alternatively, if it is necessary in some other way to show a significant change of circumstances, we will be suggesting that it is open to this court, or alternatively the county court, to accept the revised undertaking which the wife puts forward. Now, could I invite attention, please, to the Omiyale case, which is in Volume 2 at tab 22. Page 720. The financial settlement in this case is set out in the judgment of Lord Justice Thorpe at page 721. Paragraph 1 of the order provided that the former matrimonial home be sold, but the sale be postponed until such time as one of the following events occur, namely, the remarriage of the wife, her cohabitation with another man for a period of not less than 6 months, the death of the wife, or the wife ceasing to reside at the property on a full-time basis. As the judgment records, the second new paragraph on page 722, a few weeks after the making of that arrangement, the decree was made absolute and a deed of trust was executed by the terms of which the husband and the wife constituted themselves trustees, holding the former matrimonial home upon the trust declared in the paragraphs of the order. Prior to the order of the 12th of February 1990, the husband and the wife owned the beneficial interest in the former matrimonial home equally. By consenting to the order, the husband divested himself of any beneficial interest, remaining only the joint holder of the legal estate and a trustee of the proceeds of sale. The wife, the other joint holder of the legal estate and trustee of the proceeds of sale, in consenting to the order, reduced her beneficial interest in the proceeds of sale from 50 to 25%, that interest being vested but in reversion expectant on the occurrence of any event specified in paragraph 3 of the order. However, she obtained a beneficial prior right of occupation, that interest being vested and in possession, for her life or until the happening within her lifetime of any of 3 events, all of which were within her election. By the order, the children acquired a vested 75% beneficial interest in reversion, subject to the mother's prior beneficial right of occupation in possession. Then the wife gave birth to a 5th child by a man with whom she conceded subsequently she'd been in full-time cohabitation for more than 6 months. And so the husband applied for the sale of the home, pursuant to paragraph 1 of the February 1990 order. The wife applied under section 31 of the Matrimonial Causes Act for the variation of the order to postpone sale until the youngest child should attain 18 years or cease full-time education. The decision in the case is contained in the judgment of Lord Justice Thorpe at page 726, a judgment with which the other members of the court agreed, and one can pick it up at the first new paragraph on 726. As my Lord Justice Peter Gibson pointed out, a trust for sale, such as the statutory trust for sale on which the parties held the former matrimonial home as beneficial joint tenants, is not the same as an order for sale, and it would be difficult, if not impossible, to draw a court giving effect to the contract between the parties that did not contain somewhere within its terminology an order for sale. In my judgment, that part of an ancillary relief order that orders sale must be taken since 1981 to have been made pursuant to section 24A. That's the passage I had in mind in some comments I made earlier to my Lord Wilson. As the 1980 Law Commission report, Orders for Sale of Property under the Matrimonial Causes Act, makes plain, there was a general perception that the statute required an express power to order sale to settle uncertainty as to whether such a power existed and to avoid the artificiality of resort to the Married Women's Property Act in search of such an ancillary power. Thus, properly construed, the order of 12th February 1990 constituted a variation of settlement order under section 24(1) and D, to which was attached an ancillary order under section 24A.
Well, that's a bit odd, isn't it? At that stage, any joint interest in land had to be held on trust for sale. That was by definition how you held a joint interest, whether beneficial or legal. That, of course, has since changed. And I thought that Lord Justice Peter Gibson will have been pointing that out and perhaps wanting to draw a distinction between the statutory trust for sale that arises on joint ownership and an order for sale under section 24A, but it appears not.
Yes.
My Lord, with respect, I think, leaving aside what the position would be under land law and whether a trust for sale arises and when it arises, but I think what Lord Justice Peter Gibson was doing there, as quoted by Lord Justice Thorpe, was precisely pointing out a distinction between an order for sale and a trust for sale.
And the pre-existing trust for sale,
yes,
under which of the joint ownership of husband and wife, yes?
And the later trust for sale.
There's also a later trust
Yes,
for sale.
there's two different trusts for sale, yes. That's what I find quite odd about this.
Well, I think what Lord Justice, perhaps I'm wrong, but I'd read Lord Justice Thorpe as saying that in the last sentence, properly construed, the order constituted a variation of settlement.
True.
The order,
To which was attached an ancillary order under section 24A is what I'm finding a little bit interesting.
Right.
See what I'm getting at? I wouldn't have regarded the statutory trust for sale that used to arise in joint ownership under the Law of Property Act as an order for sale under section 24A.
No, absolutely not. But I think what he's saying is that there was originally a statutory trust for sale because there was joint ownership. And when the effectively measure order was made, that did two things. One, it varied the original trusts for sale. And two, it directed sale.
Yes. Yes, my Lord, I respectfully agree. So state...
Yes, there was an order for sale. There actually was an order for sale, which we see on 721.
Oh, is that right?
Yes,
Yes.
that's right. So there was one.
Yeah.
So there are two different things.
Yes.
Good. I'm glad I've sorted that out in my own head, at least.
The, reaching back into my recollection of the law of equity, I think that a trust for sale is...
It's been abolished now, Mr. Hockman, so you might as well forget it.
Move on.
It's abolished under a piece of legislation for which I had some part of the responsibility, otherwise known as tollata.
The only point I was going to make was that it doesn't require sale. It doesn't contain within it a direction that there should be a sale.
No, I realise the order contained that.
The order does.
Yes, there was an order, and therefore this is a case in which there is a Section 24A order.
Precisely.
And the question is how it should be treated, how it fits into Section 31, and that's where we are in this case.
Yes, we're going on to see how Lord Justice Thorpe said it should be treated in Omielan, which in our submission is materially different from the facts that we have here.
Right.
Because in effect, what Lord Justice Thorpe is saying is that what the wife was seeking to do was not merely to achieve a sale, I beg your pardon, not merely to postpone a sale, which is what she wanted to do, not merely to, as it were, to vary the order for sale by postponing the date of sale, but inevitably, because of the terms of the order, she was seeking to she was seeking an adjustment of property. She was seeking an adjustment of property interests, especially of the children. And that was why, varying the order for sale, revisited the primary territory of the order. And we submit that that is not the case here. We submit that extending the period of time before which the property has to be sold does not bring about any adjustment in the property interest.
Was she trying to vary the division, the distribution of the proceeds,
Well,
as a matter of fact, or not?
not the percentage division,
No.
but your lordship.
Time for it.
Well, yes, but what the way Lord Justice Thorpe analyses the property transaction
Yeah.
was such that it did involve, in effect, a reversal of the original decision as to the property interests.
And of course, it had already happened.
Exactly.
Yeah,
She'd been cohabiting for more than 6 months,
Yes.
and therefore the children's interests had already vested.
Yeah.
vested, precisely, yes.
Yeah, that's it.
So, picking it up, what about 15 lines up from the bottom of page 726? In fact, I can pick it up 10 lines up from the bottom. Section 24A is a purely procedural section inserted to clarify or expand the court's power of implementation and enforcement. Any power to vary such an enactment must be construed to be equally limited to matters of enforcement, implementation and procedure. In other words, Section 31(2)(f) gives the court jurisdiction to revisit the territory of the ancillary order under Section 24A, but not the territory of the primary order under Section 24, which it supports. So that's crucial.
Mr. Hockman, there must be a typo 5 lines up from the bottom. Any power to vary such a procedural enactment. That doesn't make sense. It must be any power to vary under such a procedural enactment. Don't you think?
Yes. Yes.
I'm very correct.
Yes. Thank you.
It's quite technical, isn't it, Mr. Hockman? Because the children's interests, although they had, as my lady rightly says, vested on the occurrence of what I can call the cohabitation trigger in that case, they weren't going to be affected at all except by the postponement of the sale. Were they?
No, it was very technical.
Well, the crucial point, the crucial distinction that is drawn at the bottom of 726 is a distinction as to whether the exercise of the Section 24A power leads to a change in the territory of the primary order under Section 24.
Quite.
And one can see why, as a matter of statutory interpretation, one can see why that conclusion is drawn.
And you don't dispute that?
I don't dispute that as a proposition, but I say that the mistake
Doesn't apply here.
The mistake that's been made so far in this case is that it is to treat that as if it applies here. It doesn't apply here.
You say if the arrangement here had been that on sale the husband should have received certain of the proceeds, or indeed, unusual though it may be, that the children should receive certain of the proceeds,
Yeah.
that would be quite different.
Yes, quite. And one can see the distinction when one sees the analysis of Omi Elan, to which my Lord Hughes has been referring, on 727, 3 lines down. Properly analysed, the wife's election to cohabit with Mr. O'Hagan had the effect in law of determining her beneficial interest in possession and of bringing from reversion into possession the beneficial interests of herself and the children in the future proceeds of sale. The application of the 20th of January 1995 seeks to reverse the termination of a beneficial interest in possession to the detriment of the holders of vested beneficial interests in reversion. These vested beneficial interests in possession and in reversion are at the very core of the Section 24 order, since they were the interests created to replace the pre-existing joint beneficial ownership of the husband and the wife. Both statute and authority show that the court has no jurisdiction to entertain an application to vary such an order.
It's really a dismantling of the order rather than a variation, wouldn't it?
Yes, yes. So, this we submit provides an illuminating view, or sheds light really, on the overall framework of the law in this area. So we know that a property adjustment order cannot itself be varied. And if the application for variation seeks to do that, seeks to revisit that territory, then the answer must be no. If we're outside that territory, as we submit for relevant purposes, we plainly are here, because the application involves no such variation, then the position is as follows. If it is a Section 31 case, whether in the form of an order or in the form of an undertaking, as Mr. Justice Munby said in the latter part of L, paragraph 113, if it's a Section 31 type case, then the criteria in Section 31 must be applied, giving primacy to the interests of the children. And it will be a Section 31 case if you have an order for sale under Section 24A. Because Section 24A is one of those classes of order to which Section 31 applies. And, as Lord Justice Thorpe says at 726, about line 20 probably, in my judgment, that part of an ancillary relief order, that order's sale, must be taken to have been made pursuant to Section 24A. Any earlier views to the contrary being misconceived. So, in the barest possible terms, in the most naked possible terms, our points are not property adjustment, but instead Section 24A, and hence to be varied under Section 31.
So to what extent are the reasons why the property adjustment order, which was made, relevant to this question as to what was the primary territory? Because what's said against you is I would not have agreed to that order on any other basis than that I would be released from my liability under this enormous mortgage, at least for somebody like me it seems like an enormous mortgage, within 2 years, basically.
Well, my lady, the first thing I would say to that is that those factors do not form part of the primary territory for this purpose. It doesn't help to use the phrase primary territory in such a loose way. The words primary territory are to be used in the following way. You have to look to see what, if any, transfers of property were made in the order, and I accept that some were provided for in our order, for instance, the transfer from the husband to the wife, but that's not affected by it. Nobody's suggesting varying that. No. Also, as we've suggested, as between the parties, the wife agrees to indemnify the husband in relation to the mortgage. That is an adjustment of liability, at least, can be construed as an adjustment of property. But again, it's not being changed. So there's no application to vary that. So this phrase, the primary territory, has to be, it raises the question whether in truth what is happening here is an attempt to change the property rights themselves, which by statute can't be done. Then, as I've said, if that's not the case, and we submit it isn't the case here, and nobody has ever suggested that it is, I couldn't suggest that. If that's not the case, then the next question is, are we in Section 31 territory? And we are in Section 31 territory if there's an order for sale under Section 24A, which there was. There was an order for sale here. It was an order for sale within 2 years. That order, the order that the property should be sold within 2 years, subject to the wife being able to release the husband from the mortgage, has to be treated, says Lord Justice Thorpe, correctly, we say, as an order under Section 24A. And that's why it's an order to which Section 31 applies. Now, my lady, to answer the question that I think you raised a few moments ago, can the husband put forward the circumstances that he was in at the time the original agreement was reached? Of course he can. It is part of the circumstances to which Section 31 applies. Of course we don't suggest that it's irrelevant or that it's inadmissible. Section 31 says you have to take into account all the circumstances. And a tribunal of fact, a tribunal evaluating the parties' cases, of course, would have to take that into account. But your lordships won't be in any way surprised to hear me say, from my perspective in the case, that there's a statutory requirement to give primacy to the interests of the children. That's why Section 31 is so important from the perspective of my case. It's not that the husband's position is as it were, irrational or irrelevant. Far from it. Of course, weight has to be given to it, but Section 31 is extremely important from my point of view. Now, the last piece of the jigsaw, although we've spent rather a long time on it, ultimately it is only one piece in the jigsaw. The last piece in the jigsaw is, even if this is not, I say it plainly is, but even if it's not a Section 31 case for whatever reason, then we have the general law allowing a court to release a party from an undertaking, even if it's 1,000,000 miles from Section 31, if it may be a planning case, a commercial case. The general law, and I've made my submissions about whether the word significant is significant.
I think we've thrashed that one out.
We have, rather. I agree. But I wanted to sort of put it in the overall context of the argument that I seek to advance. I think it was the court, on giving permission, that expressly raised the question, if I may respectfully say so, quite rightly, raised the question, can't this be treated as a case in which an undertaking can, as it were, be discharged and another one substituted, to which the answer is yes, it can be treated in that way. I wouldn't dissent from that at all. But in a sense, the decision, if our argument is correct, the decision, if our analysis of the order in particular is correct, the decision doesn't depend on that. The decision depends upon the analysis of the order in the context of statute and with the guidance of Lord Justice Thorpe in Omielan, which is correct guidance, but which applied to the present circumstances leads to the opposite result from that which in Omielan was held to apply.
Can you help me about a question of practice, Mr. Hockman, because I suspect I'm out of date. In the early days of property transfer orders, orders for deferred sale were extremely common. My impression is that they became less common. Are they still pretty common?
Your Lordship means what used to be called, or maybe still is called, the Misha order?
Often so called, yes.
Yes. My Lord, I may not be the best person to answer that question. As a matter of general practice, I'm not going to,
I realise it might be unfair.
Present myself as something that I'm not, but I suspect that they are still used.
Pretty common.
Yeah.
More common.
Yeah.
Right.
And it does follow, does it, that if you're, because if you're right, the reason I ask is if you're right, it will apply to quite a lot of orders. It'll apply to any order for a deferred sale, except one where the vesting of an interest is made contingent on some other trigger.
I suppose that's right, my Lord. But in response to that, I'd make two comments. Firstly, that's what Parliament has said. And secondly, the fact that Parliament had said that must have been extremely well known, not only to, well, in particular, to the husband's advisors. I mean, the wife is the one who has expressed concern subsequently about the order and whether it was whether she was given satisfactory advice. Your Lordships are not.
Well, you're not suggesting that the division of shares involved in a Misha order, let's call it a Misha order for the sake of the argument, should be susceptible of variation. You're only suggesting that the timing or the trigger might be susceptible of variation.
Yes.
Have I got that right?
Absolutely, my lady.
Yep.
Yes. That's my position, both generally and in this case. I mean, there wasn't a Misha order as such in this case because the assets weren't, as it were, the subject of division. But that doesn't affect the underlying analysis. The underlying analysis here is that there were certain adjustments of property, in particular an adjustment in favour of the wife, but that adjustment was subject, if you like, to a condition subsequent. It would only take effect in full form if the wife managed to achieve what the order presupposed that she would achieve, which is the release of the husband. Otherwise, there would be a sale. So I hope that in those circumstances, I am entirely right in submitting, as I do, that the order for sale, which is what it was, albeit contained in the form of an undertaking, the provision for sale was ancillary to the nature of the property transfer. The property transfer was that the wife could have the property provided that the husband was released. And to support and enforce that, there was a condition subsequent requiring a sale if it didn't happen. There could be no better example of an ancillary order for sale under Section 24.
You agreed to my Lady Hale's proposition, but I thought you were putting it rather more narrowly than that. I thought you were conceding that when somebody was asking for a postponement of sale in circumstances in which that would mean the postponement of a receipt by another party of their proceeds of sale, that would not be permissible, but that this was a particular case where there was no detriment of that kind.
Well, my lord,
Well, I was trying to work out the extent to which you did think that your propositions were relevant to Misha orders.
I don't think there's a difference, if I may say so. You've never suggested that the division of the proceeds, the 25%, 75%, or the 2/3, 1/3 can be varied. But you do also say, don't you, as Lord Wilson says, that if this order had provided for the husband to receive even a small proportion of the proceeds for sale, it couldn't now be varied.
Yes,
Yes.
yes. But on the point, I mean, let me address head on, if I may, my Lord Wilson's question to me a moment ago, which really raised the issue whether there is prejudice to the husband by the way in which the order for sale is enforced, by the point in time at which it is enforced. Now, I would answer, if I may, in the following way. First of all, as I mentioned earlier, Parliament has decided that an order for sale under Section 24A, which is what we have here, or the equivalent of it, is one which is capable of being varied. So the jurisdiction to vary undoubtedly exists. Secondly, Parliament has laid down in Section 31 the criteria by which that decision must be made, which certainly allows consideration of all the circumstances, requires consideration of all the circumstances, but imposes primacy as regards the interests of the children, which we submit here are plainly in favour of maintaining the home in being for another 2 years.
So the interests of the children you're looking at the time, presumably, that the court is considering it.
Yes.
So in a case like this, hopefully not too many of them, some 6 years after the application was made.
Well, now, in other words, yes. Has to be. My Lord, my third point, if I may, though, is to say that it doesn't follow that a postponement of sale is necessarily detrimental. I mean, that's a matter of judgment. It may or may not be. I mean, the value of the property may rise or fall. The husband in this case doesn't retain a direct interest in the value, so that point doesn't arise. But I wouldn't. All I'm really saying is that I wouldn't concede that postponement of sale is necessarily detrimental to the person on the other side of the court, as it were.
Well, that was really the same point that I was putting to you earlier. You say you don't accept that postponement of the sale is necessarily detrimental, but if in fact a person is still liable on £450,000 worth of mortgage debt, and that liability is to continue, thus potentially, not speculating very far, limiting ability to raise money on another mortgage, isn't that detrimental?
Well, my lord, my lady, other things being equal, to continue to have a liability to a third party is, I suppose, less satisfactory than not to have that liability. I'm accepting that, of course.
It's not something you'd want.
Not something you'd want.
And by definition, it must be a detriment, therefore, sure.
No, but that is a position which the husband himself accepted in agreeing to an order for sale postponed to a given date. He accepted that his liability would continue. He accepted that that debt would remain for a period of time, and that then brings us within the realms of Section 24A and thus in the realms of Section 31. Now, I suppose that it is possible that a court, if we go back to Section 31, I suppose that it is theoretically possible that a court, considering this, and applying the Section 31 test, which is at MS 376 in Authorities Volume 1, subsection 7. A court considering this could say that after it's had regard to all the circumstances and after it's given first consideration to the welfare of the minor children, the husband's interest in being released from the mortgage debt, even though the mortgage has been paid throughout by the wife, and even though she's now got a job, and even though she promises to continue to pay the mortgage for the next 2 years, despite all those things, in theory a court could decide that the detriment to the husband was such that the house needs to be sold straight away. But that would be, with great respect, a very surprising decision in this case, a very surprising decision on the facts, given that we suggest that the welfare of the children points very strongly in favour of this home being preserved, at least until till they are both able to go to university. That's the way we put it, and we certainly, with all respect, resist any conclusion which suggests that your lordships can decide that here as a matter of evidential evaluation. Without evidence being given about what the children are doing and so on.
Have you not said everything that you need to say, Mr. Holt?
My lady, I almost certainly have, but would you allow me just to review the position between now and when we resume, please?
I wasn't proposing to adjourn now. We have 4 more minutes left.
Right. Let me. Do you mind if I just review my own notes, please?
You do, after all, have a right of reply.
Yes. Lady, I'm content to leave it there. Thank
Thank you
you.
very much, Mr. Hogman. Ms. Campbell? Well, Mr. Wilson, would you like just to get your bull points in the next 3 minutes?
There is one point I would like to make, my lady. I discussed it with my learned friend before we started. There was a desire on the part of the respondent to put in 4 documents into the bundle.
Oh, the correspondence, yes.
Correspondence.
Yes. Well, that was agreed, wasn't it?
It was agreed. I just wanted formally to ask for
Yes.
permission for that. If you want me to talk for 1 or 2 minutes, I can. What I will be starting off by
I'm
saying...
sure you can talk for a lot longer than that.
Well, I wasn't going to finish in 2 minutes, but my lady, if you'd like me to begin now, I'd be happy to do that.
Yes, please.
Okay, in that case, my lady and my lords, I'd like to begin by looking at a couple of documents that have been, I suppose, in frame recently. And the first of those is at page MS 351. Which is the order made by Lord Justice Treacy giving limited permission to appeal. I think the ambit of the permission application sought to challenge the decision in Amelan, and Lord Justice Treacy says, I give permission so that the court can consider the approaches taken in the Amelian and Mid-Suffolk cases, resolve any conflict between them, and determine the correct approach to cases of the type involved here. Thus, I confine permission to what is described as the narrow point of principle in the appellant's skeleton. So that's the basis upon which it went before the Court of Appeal. And the next page I'd like to take you to in this bundle is at MS 145, which is the consent order that marks the genesis of all of this. My learned friend said there was an order for sale, but if one looks at the curial part of the order, there is no order for sale, and that's a simple fact. The point relied upon is on page 144, which is an undertaking in the event that she cannot release Mr. Birch from the mortgage, place the property on the market. But it's important in our submission to look at that order, the curial part, and see that there is no order for sale within it. And that is important because the next thing I want to do, if there is time, and if there isn't, I will continue after the short adjournment, was to take you to the case of Jenkins and Livesey, or Livesey and Jenkins. And I'll carry on till I'm stopped.
I think we'll stop you there. That's a very good place to stop. Yes, we shall look forward to hearing from you further.
Thank you.
At 2 o'clock. The court is now adjourned.